not 2013. Even as per Rajesh and versus Neha, all those things need not be stated at in the statement of assets and liabilities. We are on this your business, and what your why this amount of 4 crores so and so, and the flat at Noida.
That was, my lord, that is not, we don't own anything. I have stated before, the family court was saying it's not there. My lord, what had happened? I buy, I sell, I
So when
reinvest.
did you sell? There will be a document for that.
So
There will be a
that is
date
why
for
I made a
that.
submission, my lord. Now he is not in India, he is in America. I will not be able to produce all these documents. But 2011, 2013.
No, even what you said is you are having only one franchise as for this affidavit. As for this affidavit. And the documents which are in the public domain in the years,
That's also they are saying.
they
Let
said
me,
that it is there are three
I will
three.
verify that.
Sure. Now,
Verify
once
that.
once even one statement that is placed before this court is an incorrect statement, we immediately take the and file these kind of statements. Please come. This court on on 18/6/2025 had passed an order whereby directing the husband to file an affidavit before this court with a fresh statement of assets and liabilities, mentioning categorically about the sale transaction and about the companies the respondent wife is referring to as a business owned by husband, a clear statement whether it belongs to him or not. Basing on the affidavit, further orders will be passed. Now, when affidavit is filed on behalf of the husband, wherein the husband states that
Kindly give me a better copy. You know, this is very poor, the Xerox. I can't even read many of them. How do I scan and send it to? These are the only documents that we have.
that after he lost his job in November 2022, he could not get any other job. At his seniority, it is very difficult to get a job in a formal organization. He went into depression and was struggling to come to terms with the health and career. He had the responsibility of the daughters also, and he started looking for different ventures to generate income. Then he started leasing out his car and room in the house to generate income, and he's getting a sum of rupees $1,660 for rental for towards rental of one room, and he's getting $1,700 for renting out the cars. As a car met with an accident, now he is not getting that income, and he enrolled for a course in real estate and also opened a company in the name of Harmonia Estates LLC to do the business in real estate. The husband had no experience or expertise in real estate business, and the real estate marketing was bad. Hence, he dropped the idea of real estate business, and he has no income from the business Harmonia Estates LLC. The company named SNDK LLC is not run or managed by him. The company was renamed as SJ Luxury Travel and was used temporarily by him for a couple of years when he was leasing the cars, and this has also stopped. S&D Consulting Inc. is not managing the business and have no income from the business. It is stated that he is not having good health, he is suffering from hypertension and diabetes. He is under depression and taking medication to address these ailments and on regular medication. He do not have any job, and he has to pay the home loan, insurance, meet other expenses, and support the dependents and himself. He has obtained loan. He has also given details about the loan that was obtained for the elder daughter's education. He has paid in the year 2019, and he had paid the interest component for about 2 years. from the date of the loan in the year 2019 till she started earning in the year 2021. And when the daughter was studying in the US, he was paying expenses that were not covered with her loan until she started working. Now it is stated that he has also facilitated his younger daughter to uh, to get the loan, and also helping her on the contingency expenses. It is stated that after selling the land in Tamil Nadu and also an apartment in Bangalore, out of the said sale proceeds, he has invested about $3,000 in business, that is franchise agreement, postal annex, courier company in January 2024. He has taken a commercial space for rental and set up the establishment as required by the company. It takes 3 to 4 years to make a break even from this business, and he is under loss from the business. And the job keeps him engaged, and he has no income from this business as on the date. Land counsel appearing for the wife has placed before this court certain documents to show that the husband has come before this court with some and misrepresentation of facts. She has placed before this court the documents dated 10th February 3rd October 2013, 25th January 2010, where certain properties are sold. And where is that Gurgaon property?
My lords,
Gurgaon property, flat.
my lords, there are two properties.
Where are they?
Your lords will have that at 65, page 65, document number 4, and document number 5 at page 96. 65.
This is also 27
But
December
they are all
2012.
sold, my lord. They are not here.
2012.
12.
So as far as this statement is concerned, they
I
are not.
apologize. My lords,
You were
there are-
saying about some latest document. 2022, some property was sold, something you said, Gurgaon,
my lords,
receiving rents and all.
he was receiving rent. That is at document number 6, which was Mantri Espana, which is at page 125. He sold in December 2022. He was getting, as per his own assets and liabilities, he was getting almost about 82,000 malas. I'll tell the exact figure, my
When it
lords.
was stated before the court,
He did not state separately, but his assets and liabilities document has that reference, and I have marked that reference.
That was sold, my lord. That is based on record that has been sold. There in the assets and liabilities that has been sold.
My lords, in his assets and liabilities, he was getting 68,800 as rent from that property. He sold in December 2022.
also filed the document to show that one property was sold in the month of December. And from that he is getting rent of
68,800, my lords.
68,800.
That is the apartment I mentioned that has been sold, my lord.
The petitioner has placed before this court the postal annex which the husband was referring to, that he has started a business with $3,000, which for the breakthrough, it takes some more time. And as of now, he is not getting any income. She has filed certain documents to show that along he is having 3 franchises And as on the date of filing of the affidavit, he has already started. Earlier, he started two, and the third one is started by the date this affidavit is filed before this court. And also, she has placed before this court she say she is submitted that, in fact, even the is sponsoring the Diwali fest, which shows that the husband is earning. And further, if not getting any amount from the business, he wouldn't have started. You wouldn't have initially he started with one. Now he has extended to 3 franchises, which shows that the husband is having enough income. It is submitted that the husband has placed the statement of assets and liabilities, placed the bank statement. In the said bank statement, it is shown that these are the fixed deposits. 1,08,730. What is that?
It is shown even
Which
in
one,
the
ma'am?
earlier. It's not only now, it's there in the earlier also. I will explain that, madam.
On 9/9, an entries of 9/9/2024, 26/1/2024, and 26/1/2024, an amount of rupees $1,08,730, $1,50,000, and $4,00,000.
Rupees, madam.
It's rupees.
Yes.
It's 1,08,730, 1,50,000, 4 lakhs, coming to a total of 6,58,730. Was the fixed deposit. It is submitted that on 6/1/2025, and on 6/1/2025, and on 8/1/2025, on different days. It shows that he has spent the amounts. It is stated that he has spent the amounts for his girlfriend, and when he has the money to spend for her, and he has no intent to support his wife. It is submitted that at every step there are suppression and misrepresentation of facts. In spite of an opportunity that is given by the court, still the husband has not come up before this court with clean hands and with true facts. Next para, having got the counsels on either side, where is the documents that are placed before the court? The documents that are filed by the wife with regard to the transactions, which are much prior to the transactions which are of 2010, 12, and 13. At this point of time, this court need not look into those documents, as even as per Rajneesh versus Neha, the statement of assets and liabilities need not contain about all these details. The crucial aspect in this case is the husband says is having one franchise by spending an amount of rupees $3,000.
Well, it's $3 lakh.
$3 lakh by spending an amount of rupees $3 lakh, he has started that franchise. The material that is placed before the court by the wife shows that he is having 3 franchises. Learned counsel for the petitioner submits that as those documents are served at the time of arguments, she needs to get instructions in that regard. With regard to the amount that is received, when a particular facts are stated in the affidavit, the petitioner, the husband, as well should have filed the supporting documents. The video that shows about that he was sponsoring a Diwali event. Those things in the facts and circumstances, what has been placed in the form of an affidavit appears to be a response needs to be filed by the husband. It is also stated in her contentions, there is a house in yours which stands in his name. that aspect was also not brought to the, she was saying about one house in the US.
We have stated that we have. It's partly.
No, my
owned
lords,
by us.
that's another one. This property is not.
What is the place that, that
I will tell, my lords. In fact, I have
the wife's
produced,
contentions?
your lords may have that at
Give a better. index.
156.
150?
156 of the document that I've produced today, my lords. This property is not this property that he's agreed upon. This is 11151 Yellow Leaf.
That he is having a house. 156. What?
Yeah, yes, 156.
It's 11151 Yellow Leaf Way, Germantown, MD. It is submitted that this particular house was not disclosed and which is in his name, in her contentions. And again, now come to the discussion. Even with regard to the house, there is no whisper in the statement of assets and liabilities or in the affidavit that is filed before the court. On these aspects, the petitioner, the husband, shall file an affidavit responding to all the contentions that are advanced and the documents that are placed before the court. And in support of his contentions, whatever the documents is referring to or the transactions is referring to, he should file an affidavit before this court. If there is any suppression or misrepresentation of facts before the court will initiate perjury proceedings against the husband and also dismiss the petition with exemplary cause. This is matter 2 weeks.
My lords, he has notary services also along with.
Yes, this is matter on 4th of August.
My lords, he, in this postal annex, he also does the services of notary. Like notary is at his liberty. So 1 week or the fastest FedEx comes. Okay, man, 2 weeks, my lords.
We shouldn't push it too much.
2
Because
weeks.
when he has to file all the documents, we have to give him some reasonable time.
My lords, may I kindly make one mention? It was a mistake from my junior. The first page of this document, my original copy is put. I'll put the Xerox of it and take the first page, my lords. Much obliged, my lord.
What she is asking. Yes, Nick.
Adu one first page. First page.
Yes, next.
List number, serial number 2, Bharat Kumar S. Petitioner. Venkat Ramana MD.
Delete from the caption for dismissal.
My lord, I'll pass over the acknowledgement for having served the IA copy to them as the office raised the objection.
The counsel for the respondent and counsel the petitioner submits is already received the document, received the copy from the
IA.
counsel for the respondent. Next. What is IA number 1024 objections?
My lords, one submission, my lords. They had filed one appeal, my lords, in RPFC 204 of 23. They had filed for enhancement. I had filed for remanding the matter.
What is the number?
It's RPFC 204 of 23. That should be connected, my lords.
How can it? When
No,
already
no,
RPFC.
that is the,
Please, 1 minute. If RPFC is filed, what is this writ petition?
No, that is the petition which I had filed, my lords. This petition, they had filed for enhancement. On the same order, my lords.
No, against an interlocutory order, either you or him have to file a writ petition,
Yes, my lords.
isn't it?
I not
So
filed a petition.
either of the applications have to be dismissed.
Yes, my lords.
Writ petition is filed against a final order or an interlocutory order.
Interim.
Final order, and also I had filed one application, my lords. It's on the final order, my lords.
Then why did you file a writ petition?
They filed
Our
the-
petition is maintainable.
They have challenged the order on IA, my lord. By that time, the
Final
matter has
order
been
is passed.
disclosed.
Yes,
Then this has to go,
yes, ma'am.
Yes,
if this has to go, this has to be dismissed.
Yes, ma'am. No, my lords, one submission here.
Mr. Counsel, interlocutory order you have questioned. In the meantime, final order is passed.
Passed.
That interlocutory order has merged with the final order. How can you
Yes.
question this interlocutory order?
maintain.
Is it not?
My lords, one submission is Now the respondent is in good terms with me, my lords. I'm pay.
We'll not go into all that.
I will make one submission in the.
1 minute, 1 minute.
Yes.
I'll ask you, you can make the
Yes.
submission. Where is the order impugned?
Operative portion is at page number 56, 55 and 56 of the writ paper book. 56,
Sir, yeah.
55 and 56.
Page number 15, my lords.
Ink page 55 and 56.
This is not in the IA. This is a final order.
But what is their prayer in IA1? My lord, kindly see the prayer. This is, at the time of filing the writ petition, this matter has been disposed of. They have challenged the IA order.
My lords,
Your lords, kindly see the writ petition.
final order and one more IA, my lords. Annex
One more
area
IA
is
what?
the, I had filed an IA perjury application.
Let me look at what is the prayer that you're seeking.
Yes.
Please come to the
Page number 13, my lords.
page number.
13.
To
It's
quash
annexed
the
area.
order passed on,
IA.
IA filed under section 195,
340 of
350
CRPC.
stated past and criminal miscellaneous, so and so.
And final order also, my lords. That's annexed B. Both orders was passed in the same day, my lords.
How can you maintain a writ petition against the final order?
Revision
You
is.
cannot. You have to file a RPFC.
Please.
There is efficacy remedy.
Hmm?
There is efficacy remedy available. How writ is maintained.
Please come. The,
And in view of this, I am not getting even 1 rupee since from last 2 year maintenance.
stay in this.
That is why.
No, my lords, whatever after saying this,
The petitioner has filed this writ petition questioning the order dated 13/4/2023, passed in criminal miscellaneous number 1/2022 on the file of the Principal Judge Family Court at ODP. And the other prayer that is sought is to quash the orders passed on IA filed under section 195 and 340 of the Code of Criminal Procedure dated 13/4/2023. In view of section 19(4) of the Family Courts Act, the petitioner cannot file a writ petition against the order passed by the family court where a maintenance where a final order is passed granting the maintenance. Accordingly, the petitioner is at liberty to convert as far as is at liberty to file a fresh petition as far as prayer B is concerned. And the stay granted by this court as far as the proceedings in criminal miscellaneous are concerned is vacated. Yes, within a week, he shall file a appropriate petition.
One submission, my lord. Till then, let them pay the maintenance, at least 1 word, my lord, because it is continuity.
I've been paying maintenance from the date of the orders passed in trial court.
I have
Not even a single
vacated that
month.
interim order. I have vacated the interim order.
Yes, my lord.
Even today, I've been paying the maintenance, my
Yes.
lords.
Next.
That is for child, not wife.
Yes, yes.
Much.
Next.
That is was the order passed by this honorable court, my lords.
One is only as far as second relief is concerned, and the necessary amendment shall be carried out in this petition. Accordingly, I number 1/24 is also, no further orders needs to be passed on I number 1/24. Yes, next.
Cell number 3. Manoranjini Thomas.
What is this party in person?
Initially, she was in a party person, then legal service committee has referred.
Yes. What is this petition about? What is impugned order?
Page
There is impugned
number,
order. Sir
page
Counsel.
number 81, Your Honor. So the court has been passed an order in a MC case 6657. Petitioner and counsel was present, hence the respondent in the person, petitioner and his counsel absent pursued the affidavit by the respondent in person 27/9/2023 in respect of IA filed under section 151 of CRPC seeking protection to enter into the matrimonial home at number 302 8th Main Pipeline Road, Vijayanagar, Bangalore, in terms of directions given in the order dated 21/12/2021. On pursuant of order sheet dated 21/12/20, in presence of both counsel, IA number 4 and 5 are allowed on cost of 250 each. But later on, 18/3/2023, the respondent filed a IA under section 151 of CRPC seeking police protection to enter into the matrimonial house. On 28/6/2022, the petitioner counsel has also filed a IA number 6 under section 151 of CRPC to recall the order dated 12/12/21, disputing the consent given by him on 21/12/21, stating that he has not given consent to IA number 5, and the respondent also filed objection to the said IA number 6. Meanwhile, the counsel for the respondent submitted that there is an order passed by the Honorable High Court of Karnataka directing the petitioner to pay sum of rupees 12,000 as a rent and also to deposit the advance amount of rupees 1,20,000, and subsequently on 30/3/2023, the counsel for the petitioner filed memo with copy of demand draft of rupees 1,20,000 and another demand draft of 12,000 and submitted the original DD will be handed over the respondent in the contended case at connected case at MMTC 5. However, subsequently on 25/9/2023, the petitioner counsel filed a
What is
memo.
it she wants?
Actually, she wants to enter into the matrimonial home, Your Honor. That's her prayer. Because she
But
has,
That order is passed in which case? In MC, that order is passed.
yes, Your Honor.
What is it, Mr. Counsel?
Lords, it's a purely abuse process of law. What happened, Lords, may I say, Lords? One petition is filed by the husband for divorce. That is the MC 6657 of 2019. Another petition is filed by the wife in criminal misdemeanors 109 of 2019. Not initially, she filed an application in the DV proceedings seeking for a residential order. The magistrate said that is not suitable. Let her be provided with alternate accommodation. That order was challenged before in the Sessions Court in the criminal appeal. Criminal appeal also concurred with the said order, said alternate accommodation is the suitable, considering the circumstances between the parties. But they came up before this honorable court in criminal revision petition 605 of 2020. Even this honorable high court said, no, it modified, it enhanced the advance amount on the rent amount and found that is suitable, because this court interrogated the parties and found this is not suitable. Let her be alternative accommodation. What happened is, in my divorce case, they filed two applications. One seeking for objection to the merits, the main petition. Along with that application, they filed one more application seeking that restraining order, that I should not be thrown out of the residential order. I'm not suppressing all these orders, the DV proceedings.
So why is the MC matter, why the court will go into all these
Not-
issues?
Together they filed the application. What happened, Lords? We thought the application is for the application.
They're before the same court.
They are different courts, family court and the magistrate courts. Not in the family court, what happened, they suppressed all these orders. Suddenly they came up with the two application, one seeking to file objection to the main petition. Along with that, they filed one more application for residential order. What happened, we submitted no objection to the application, for which they filed objection to the main petition. But court recorded that we had said no objection.
When already an order is passed in the DVC case, against that, the district court, then the high court, then that has.
They could not have filed another application. Now they want to enforce
Why,
it.
how can the correct court?
They have
is
filed that
correct?
application. They want to enforce police protection order. It's a mischief they have played.
It is kept in abeyance, no order is passed.
No order, because the court felt.
So what is the business of the family court in all these issues?
One mistake happened, because we said no objection to the filing objection to the main petition. Court records no objection to both the petition. They take advantage and they file an application for police protection.
Please advise her that how family court can do all these things. She has already filed a petition under the Domestic Violence Act. seeking all that injunction, restraint, whatever orders, proceedings have attained finality. And if she wants any other order or anything for that, she has to go before that court. How can all these petitions be maintainable before
He
this
has
court?
filed 151 application, Your Honor, seeking for a protection for the
So how can
thing.
she enforce
First,
it?
initially, the court has given to enter her into the matrimonial house, and they are not
That-
allowed. And she seeked for a police protection, still they are not allowed. So
Where
now.
is the order? Where is the order to enter into the house?
Not Annexure G, page 63, letter answer it. Orders of this honorable court. Annexure G, page 63. By light of that, how can she maintain another application before the family court? And this court has said.
What about alternative accommodation? Have you
Yes,
provided
Manoj,
the
that,
money?
Manoj, everything, I produced the order sheet along with the additional document. Day to date, we are filing the, as directed by this court, we are giving the DD.
12,000.
12,000, yes, Manoj. 12,000 rent, yes. Up to date, we are paying. Not even a single default.
Ask her whether she receiving that money or not. 12,000.
She has not taken the money, Your Honor. Actually,
Why?
she need the house to go back because she,
How can such an order be passed when already such a relief is negatived by the courts? Till the Supreme, till the High Court? No, it cannot be. She cannot have it.
Your Honor, she is very young and how can she stay alone, Your Honor? Where is the protection in Bangalore? And also she have to, now she is staying with her
Please
parents.
tell her, it is not, don't tell her what all her emotions are. What legally permissible, you tell the court and you tell her.
I told.
That's her. Whatever she says, that can't happen.
No,
You have to tell her, you have to advise her. She cannot have that order from the family court. And already that whatever she sought, it is rejected by the two courts, which is confirmed by the High Court. Finally, court said pay 12,000 towards her the rental accommodation. That will be done. All these let her forget and peacefully live in that house. Please come.
And there is a pending amount they have to pay, Your Honor.
That you can tell the court what it is.
Yes.
From when is the direction to pay the amount? From which date?
Not in the order itself, it records, my lords.
Where do you get that order?
Not page number 84, my lords.
84.
Yes.
First of all, why that, how the family court has numbered that kind of an application? Where do you get
No,
that?
sir, I have produced the order sheet of the minutes along with the additional document minutes.
Page
is-
number,
It's filed on 20th March 2025.
number.
That's page number 75. 70. That's page, sorry, page 66 minutes.
Now, I'll take up this matter tomorrow.
Please,
Let her calculate and tell how much is the amount what is it?
Due.
How much is what from that day till today, how much is the amount? What is paid? What are the arrears? The small statement you made, that we will give, will pass a direction to the husband to pay, or else we'll say,
I produced the order sheet up to date, it's paid. Lordship have to say page
Let
number.
her- let her give
Let her
your
also
question.
have a say.
yes, the petition shall file before this
My
court. the
kind
cali-
submission, Your Honor, because more than the money, she need a emotion.
That is not possible. Please understand. She might require or her needs or whatever they are, but they can't be done. What is permissible, that only court can do. The petitioner shall file the calculation memo showing what is the amount due from the husband as per the order of the High Court at rupees 12,000 per month. Tomorrow.
Please, please.
Yes.
Serial number 4.
And please advise your client by that time, let him calculate again. If any arrears are there,
Yes.
by tomorrow, let that be cleared.
But I will file a affidavit because I produced the order sheet. Up to date, it's paid. Let
Calculate
them-
and tell her, and if it is, if at all any
That
amount
is
is
also
there,
due, we will pay.
paid by
We'll honor it.
tomorrow. Yes, next.
Serial number 4, Ganesh K.
My lord, I am challenging the order number
Can't be. One prayer it is maintainable. For the second prayer. Writ petition. This writ petition will be there for the first prayer. Second prayer, he has to file the other petition. Yes.
My lord, I am challenging the IA.
What are the non-compliance of office objection?
My lord, insofar as office objection is concerned, I have filed a certified copy of the order in page number 37, my lord. And the office objection is it has to be filed with the preamble. There is no preamble, my lord, because the order was passed in the order sheet.
The council submission with regard to the office objections is accepted. Yes.
Yes.
What is the
My lord,
important?
here I'm the husband and challenging the interlocutory order passed, order dated 19/9/2024 for a payment of monthly payment of 20,000, my lord.
Is what is your income?
My lord, the fact is, my lord, I was married in 2017 and marriage lasted only for 1 year, my lord.
What is your income?
Right now, I am unemployed. I will state, my lord, the problem I am going through. My lord, my mother is suffering from recurrent stroke starting from 2009. The only demand of my wife is to get rid of her. Right now, my mother is home ridden, my lord, bedridden, and my lord may go through page number 102, medical report, and 102. This is from a Rashtrotana hospital, my lord. My mother, Sunanda Dinakar Holla, and I want to state, my lord, I don't have.
You are a BE graduate. Why you are not working?
My lord, my mother is bedridden. I have to take care of her, and I don't have father, and I try to work from home. And my elder brother, he stays in a separate residence. There was a manhandling of my mother by his wife, and my mother is unwilling to move there, and she's.
Have you filed your statement of assessor liabilities?
Yes, yes, my lord. There was a delay, but I filed it in divorce proceedings in time because divorce was filed much in advance. I filed it, and there are a lot of proceedings in between in the maintenance proceedings, my lord. As on today, I filed it, and
On today, when this application was decided, at that point of time, you should file.
I actually both the proceedings were happening before the same judge, and in divorce I filed it, my lord, on time, and there was a delay in filing.
Maintenance was granted where she sought for maintenance.
What is that? Please.
Maintenance in criminal miscellaneous.
Yes, criminal miscellaneous, but
You filed there in MC.
no, she filed MC first before the same judge, and in 2020, and there was a lot of negotiation, my lord, to bring her back to matrimonial home in 2020 itself, my lord.
Arrears also.
My lord, please, my lord, please go through page number one.
Pay half of the amount.
My lord, she is also B graduate, my lord.
See, once she comes, all, no, for everything, where are the statement of assets I have filed in MC? For everything, you have some answer or the other.
As on today,
Let the wife come, then we will see. See, half of the amount, arrears at 10,000.
my lord, I can pay 1 lakh rupees, my lord. Stay may be granted. I'll loan it from my brother.
10,000 per month and arrears at, towards arrears, 1 lakh within 4 weeks. Yes.
4 weeks, my lord, for compliance.
Serial number
What
5.
you want 5 months?
No, 4 weeks, my lord, for
Said,
much obliged.
Serial number 5. Ravi Shankar.
yes.
My lord, there is an urgency in this matter, my lord. Today, the matter was posted for final judgment today, my
Provide
lord.
service of notice on
My lord.
R1.
I serve the end summons to the.
Where is that? Where is the memo? You should have filed it. I said, if the memo is filed, list the matter. Without filing the memo, you
No, my
move
lord. Yesterday, I filed the memo, my lord. I have a
Where
copy.
is it?
I have a copy.
What is the name of the advocate?
On 7, my lord, sir, the counsel who appearing in
What
the
is the
respondent, my lord. Name I mentioned in the memo, my lord. I have not, just,
MC is of which year?
my lord.
MC of which year?
My lord, this is not MC, my lord. You receive his petition under section 127 for enhancement of the earlier order, my lord. In this matter, my lord, I filed an application, my lord, under section 91 of the CRPC, my lord, on 31/2025, my lord. In my application, my lord, may I read, my lord?
What is that? Ananta Kumaraya.
Please,
In the name of Mr. Anant Kumaraya, list this matter tomorrow.
my lord. Today, the matter was posted for judgment, my lord. Kindly direct the trial court not to pronounce the judgment, my lord.
This will
Otherwise,
not
it,
stop the court from doing anything. Yes, next.
Hearing on interlocutor application, CL number 6.
Yes.
Yeah, but petitioner in this case, my lord. Delay application, kindly consider along with our main, my lord. Stay application is allowed, my lord. Yes, for 2 weeks time.
This is matter. No representation for the respondent. This is matter on 19th of August. Yes.
CL number 7.
Appearing for the petitioners, my lord. My lord, the petitioner and the respondent got married in the year 1998.
Govind Raju first. There is a respondent.
In June 2020,
Protection rights that have been granted to the father, my lords.
serial number 7, Your Honor.
Limited submission in this matter would be every weekend has been granted visitation rights from Saturday till Sunday 2 p.m. From Saturday morning to Sunday 2 p.m.
Look at the order.
Please, please. Page number 42 is the operative portion. The operative portion is about a bit lengthy, my lords. Runs up to 4 pages.
Let's see, I number.
Page number 42, my lords.
Boy or a girl?
It's a girl, my lords. 8-year-old.
Respondent is the father.
Please.
Hmm. GNWC is filed by whom?
By the mother, my lords.
Huh?
By the mother, my lords.
Hmm.
There are multiple litigations between the parties, my lord, which I would not want to stress upon at this point of time, since the
Saturday 10 a.m. till 2 p.m. on Sunday.
Sunday, every
That's
Sunday.
overnight custody is given.
Yes, yes, every Saturday and Sunday, my lord. What happens is the mother does not get the time to spend.
Respondent shall have the interim custody of the child during the summer vacation. That you are not bothered.
My lords, I have challenged, my lords, but as of now, the
Shall have the interim custody of the child for the initial 50% of summer. Onam festival, so and so. Court had taken care of everything. Birthday. So only you are on this.
my lords, I am on the entire order, my lords, but page number 140. I'll just, my lords, I had in fact made a proposal in my objections to the application. Just take that page number. Page number, my lords. I'll just.
What is the age of the child?
8 years old. But in respect of the weekend custody that the father has, my lords, the mother does not get the time to spend, my lords. If every week is given, my lords,
You're a working woman.
she's a working woman. That being the reason, every week, if we can, at least 1 week, my lords, alternate weekend, my lords, with the father and with the mother, my lords, would be a fair aspect, my lords.
Then, Mr. Arundash, what we do is, on alternative weeks, let him have this, and on every week, let him have during the day, let him have the visitation. Alternative weeks, let him have the overnight custody. On the, for example, 1 and 3, if he's having
Understood.
2 and 4, let him have the day visitation.
No, this is an arrangement going on by consent for the last year and a half. It is not something new that the family court has imposed upon the mother. By a joint memo, every weekend I've had custody from January last year.
Where is that?
Consent order, my lord, page number 230.
There are 2 joint
My lord,
memos.
I have a preliminary objection. My learned friend, my lord, is a champion for fathers' rights. I think he should not be allowed to.
Sir. Page 227, my lord, the first memo.
230?
Not initially the joint
227.
memo filed before the family court, where the mother said the father can have visitation every weekend. She violated. I had to come before the court in contempt, not before this honorable court. Page number
I
228
can
is
see
the
the
order.
contempt.
On 15th of February, kindly see page number 230.
232 contempt as well. Joint memo in contempt
230.
also.
Paragraph 6.
So let's look at that. Then why are you winning away from this?
My lords, what
Not thereafter, sorry, not thereafter. 230 is the submission made by the mother's counsel. The
38.
response, page 230.
230.
30. Respondent has no objection for the father to have the company of the child to pick her up on Saturday morning and to drop her back on Sunday before noon. This was on
No,
15th
230,
February.
I don't find that.
Not the, I'm sorry.
So Dixit submitted that. Respondent has no
Contempt.
objection.
Yes. Thereafter, my lord, a joint memo is filed before the family court on 24th of April, 2024, listing out all visitation that the father will have, including birthdays, vacations, family occasions, everything, my lord. That memo they have filed. Page 230. At page 232. Annexure H.
Yes.
So may I read, my lord, page the annexure H. Regular visitation. Both the parties hereby agree that regular visitation to be commenced from 1st June 2024.
Yes.
Respondent shall pick up the.
Yes, Mr. Gautam.
ballots. But I'm not denying that I've not filed a joint memo, my lords. But my
Then
lords,
what is-
custody orders quite often, my lords, my lordship is aware that they're never final. What's happening is, my lords, to be very honest, because of a work schedule, what happens is she does every Saturday and Sunday if the child is with the father. When does the mother get to spend time, my lords? That is one of the most important reasons. That's the reason, in fact, I advised my colleague as well that
Then in that case, we'll do pick up on Friday evening and pick up on Friday evening instead of Saturday. Pick up on Friday evening from the school.
Lord, what happened is this. This is IA number 12 that is challenged. IA number 11 is filed to shift the child's school from my lord Hebbal to Whitefield, where the petitioner wanted to shift. That IA was allowed. The objection of the father in that IA was the entire move is only to alienate me from my child. My child and I have a very good relation. Lord, she's a career woman. I unfortunately may not have not been able to do well. In fact, the reason for the dispute is that I'm not. That's the ground taken in the divorce petition filed by the wife and also in the custody petition. I have been taking care of my daughter throughout, from the time of her birth, because the petitioner is quite well to do at her workplace, and she's been making big strides, taking big strides in her employment. The child is extremely attached to me and to my parents because we have been taking care of her. All I'm saying is, if I understand, 3 weekends, not Friday evening to Sunday, I'll drop the child back by about 12 o'clock on Sunday so that the mother also gets Sunday with her. 3 weekends in a month, kindly permit me to have, because otherwise I have absolutely no access to my daughter. She's moved very far away now from where I stay.
Well, it's Friday, Saturday proposal. I'm absolutely all right with that, my lord, because we would be grateful, in fact, if it's modified to that extent. My lords, in respect of my learned friend submitting that he's not working, my lord, I have his profile as to,
that's
I
not
will
the
not
issue
get into
now.
that, my lords. My lords, I am on a limited aspect. And also, my lords, the fact that you're taking visitation rights, but you're not willing to pay maintenance is also something that needs to be considered. My lords, my lords is aware as to how it works, my lords. So visitation rights and custody is not the only thing. You should be a dutiful father by taking care of the child's educational expenses, at least to the extent of 50% is what I could.
I will pay 50% of educational expenses.
Please.
So now how it's going to be? It's Friday evening to Saturday. Now what you can do is, now it is 10 a.m. to 4 p.m. the next day.
Yes.
If it is Saturday, you can
Sunday.
Friday. If it is Friday, if you take him, what are the school hours?
3 o'clock, 2:45. The other thing is school. After she shifted the school, the father's name is not there. He is not given any access. That also may not.
3:30 the school, in fact.
No, what I'm saying is 3:30 of Friday to Saturday late night.
No, she stays in Whitefield. Sunday, I will drop her back on Sunday morning. As of now, I have Saturday morning to Sunday afternoon. This is not a new arrangement like I mentioned. This is by consent of the parties. It's been going on.
Could be consent. I'm not really denying that. I'm definitely not denying that. What I'm requesting is, my lords, in a month, all the 4 Sundays with the father, mother hardly gets half a day with the child on a Sunday. If they could drop the child back by Saturday night, Sunday at least the child would be with the mother and the mother could take the child out wherever she would want.
Why did you move so far when this arrangement is
He's
going
working
on?
in Whitefield, my lords. That was the
That,
reason.
sorry, my lord, she works in MG Road.
No, she's
Her
working. in
employment is at
Whitefield.
MG Road. She moved from MG Road to Whitefield, saying that it's, and then she moves the child's school also. my lord. So, my lord, there's much to be said.
Parents are
My lord, in
also
the
in
domestic violence case, she gets an ex parte order of protection and maintenance, suppressing the order, the joint memo filed before the family court, the submission made before the contempt court. The domestic violence court will not take serious note of her conduct. And my lord, there's some serious
But if it
findings the
comes to
court
conduct,
record.
I can show you a few messages as to what the anger issue the respondent has. I would not want to really harp on those
So what we
aspects.
do is,
Absolutely
let us-
not, my lord.
no, you filed the writ petition. We'll say 50% of the education expenses, father is ready
Yes,
to
please.
pay, and he'll pay, and we'll conclude it there. Agreed with the orders passed in. IN number.
Friday to Saturday is what I believe, my lord.
Huh?
If that portion could be modified, Friday to Saturday, Sunday I'll get.
No,
my lords.
there is one more suggestion, what
Please.
Mr. Govinda is suggesting. For three weeks, let this arrangement go on. On the fourth Saturday, let the girl be with
My
you.
lords.
On the fourth week. on the fourth-
One Sunday in a week, my lord. How fair, my lord.
No,
My lords in
no, out of.
other, my lords
Because,
in other matters.
no, with all this that's happening, no, it's not right. You are happy. You only come forward with all this. Agreed with orders passed in I number 12 in JNWC number 12 of 2024, dated 23rd April 2025, whereby the court had granted visitation to the father. The mother is before this court. By way of order, Imperial Court had considered the visitation on festival days, on birthdays, and on all other days, on the summer vacation. The main argument of the learned counsel for the petitioner is that on the first condition, that is, the mother is directed to hand over the interim custody of the child to the father on every Sunday by 10 a.m. till 2 p.m. on Sunday. Learned counsel submits that if every Sunday, if this arrangement goes on, absolutely there is no time for the mother to spend qualitative time with the child. It is also submitted that the father is not at all taking care of, is not providing, is not taking care of the needs of the child, and there is no contribution from the father. Learned counsel appearing for the respondent, father submits that already from basing on the memo that is filed, and as per the arrangement and understanding between the parties, this is going on from a very long time.
My lords, my only submission, page 286, in respect of pick up and drop. Let him pick up the child and drop the child, because 286, my lords, states as to what the man is of. Basically, his abusive and aggressive nature. I'm 3 minutes late. He sends an email. Please see 286. My lords, a coin always has two
Where he
sides. my lords.
stays,
Richmond Road.
Richmond. Let him pick up and drop
what's
the child.
the
my lords.
distance between this
Please
and
see
that?
286.
About 16 kilometers. My lord, the arrangement was while she was staying, my lord, near Hebbal, I used to go pick up and drop. It was only 6 kilometers distance. Now she's moved 16 kilometers. The family court was very conscious, my lord, while passing the order. Since you have moved all the way on your own request,
Happened in Hebbal.
one way you drop,
This
one way he will drop.
mail is pertaining to Hebbal, my lords, because please see the mail, my lords. Even if I'm too, please see the mail, my lords. I cannot say anything more than this, because my lords, he has anger issues. That being the reason, my lords. But
So
still,
we're not on that point. No, you
my
have
lords,
moved.
but he is
You have
abusive.
moved
I'm not
to-
stating anything else, but I've advised the client. Visitation is something that should go on. I'm not denying it, my lords. But my lords, at page 286, if these are the mails that I'm going to get and
How
harass.
do you expect him to travel all the way to Whitefield and no, half of the time is
My lords, by
gone in
metro,
that.
it's 25 minutes, my lords. From MG Road. By metro, it's
I think my
25
learned friend
minutes.
must do the commute. He will find out how long it takes.
That will not.
At least a midpoint, my lords, a midpoint should be fixed, because my lords, every time I
Where will
receive
you
a
drop?
mail, every time I
No,
receive
that
a mail,
creates all the more problem. Either you are able to reach or he
every
is not
time
able to.
every time I
And
receive a
again,
mail, my
court,
lords.
you people will, by applications will increase the court's work.
And also, my lords probably would have to also address on the aspect of video calls, which are going on for 2.5 hours, 3 hours.
That's
with the
addressed in the
child.
interim order.
My lords, that would have to be modified, my lords. My lords, Mother has nothing ultimately. If the days that he does not have custody, if he's on video call with the child for 2 hours, 3 hours, my lords, where would the mother go, my lords? Please, my lords.
Every day there is video call.
I have.
No, the lordships are reduced by your lordship's interim order is reduced to 15 minutes per day.
My lords, I've produced the screenshots as to how many hours the video calls are going on for. 307, my lords, please. 307, my lords.
Order is here, my lord. Passed on 29th of April.
Where is it?
29th April order, your lordship's order.
307, my lords. It says 2 hours,
Sir,
1
one
minute
second.
video call.
1 second.
Yes, sir.
Point number 2, subpara 2.
Oh, already one line is over. One round with regard to the summer vacation is over.
The same writ petition, no? In this writ petition
Oh,
itself,
no,
the interim order.
no, because that is addressed. Now he's coming to point number 1.
My lords, it's only the order, my lords, is only for summer vacations.
Yeah,
And as on
because
2000 continues,
Mr.
I
Bondal,
have.
if you look at the order, point
Yes.
number 4 says,
Yes.
the earlier order with regard to the weekend visitation, the video call and whatever the arrangement that is made by the court will come into effect from 3/6/2025.
Yes, my lord.
So from 3/6/2025, the order of the family court will come into play.
Yes, my lord.
So what is the order of the family court? How much time?
There is no
There's
video
no
call.
time fixed, not everyday video calls. The child calls, the mother gets back home only at 8 or 9 o'clock in the night. From 3:30, the child is there with the grandmother. She calls when she wants to speak to the father.
And can't have the cake and eat it too is what I can say, because my lords, what happens is it was only till summer vacations. Now even recent calls I have, he's spoken to the child for 1 hour when there is no video call. Well, this shows that the mother is being gracious does not mean you take advantage of it.
No, it's not that
Is
he
what
is
I could-
speaking, child is speaking.
What is the advantage here? The child is comfortable. Nobody is
Not
compelling
to the
her
extent
to.
of 1 hour, my lord.
Child is talking, my lord.
Not to the extent of 1 hour, my lords.
See, the
When,
8-year-old
when will the mother get the time to spend?
8-year-old child, she
child.
does not want to speak. She will convey to her father, I want to cut the call.
But
The
it's
child is speaking. I don't know why my learned friend, my lord.
307, my lords, will page 307 clearly.
Between
speaks
them,
for
there are
itself.
any.
So what we do is only that Friday, Saturday to Sunday for 3 weeks, not all the 4 weeks. And I mean for weekends, on all four weekends, 3 weekends. That will modify.
May I make only one? No, my lord, I understand the mother also is working. She needs to spend time with the daughter. The 4th weekend, my lord, may I pick up the daughter on Friday and drop her back on Saturday? My lord, at least I'll get some time with her. That's all.
Yes.
3 weeks, the mother is not getting any time with the child, right? So that's the reason.
That should be the ideal thing for both
Well,
of them. If it goes
324
on for
also.
the 4 weeks.
324 also, my
No,
lords,
for
page.
all for the entire month, the weekends, if it goes on like that from Friday to Sunday, it would be better. Sunday, traffic will be less. Late night you can drop. Late night you can drop.
Friday to Sunday. my lord.
Saturday. That's anyhow you are getting one day. For example, you're picking up the child at 10 o'clock and dropping her back at 4 o'clock the next day.
2 o'clock.
2 o'clock the next day. So now you will pick her up on Friday and drop her back on Saturday night, late night. It'll be more.
No, we'll pick up the child in that
Huh?
case. We will pick up the child.
Night, let them come and pick up.
We'll pick up.
So that's like both of them. It's a good arrangement for both father and. No, what is the difficulty of the father for that arrangement? He wants to have a overnight custody.
Also, my lords, the reason why I said video calls was because she needs to study. Page 324, he's been sending messages to the child. You have to call me. Why are you not calling? I really don't want to press on all these aspects, my lords. Screen time should always be reduced, is what I would suggest, my lords. Having a phone, 8-year-old having a phone is not good.
So if she can drop the child on Saturday afternoon, not Sunday evening, we drop the child back. From Friday evening to Saturday evening, Saturday afternoon she had the child with her. And Saturday afternoon, we drop the child, on Sunday we drop the child back.
Yes. Now it is Saturday, 10 o'clock, I think.
My lords,
Now it can, huh?
all that I am, my lords, is seeking is let there not be any change to the timings. All that I, in fact, requested our lordship's intervenances was in respect of making it alternate weekend. That was my first proposal. Alternate weekend gives fair bit of time for both the parents, for the mother as well as the father, is what my suggestion. Later, my lord's suggestion of Friday to Saturday, I'm willing to pick up the child from the father's place on Saturday. I'm willing to do that, my lord, which seems to be a fair suggestion. My lord. That way, I get a Sunday, my lords. I get the Sunday because he'll anyways have from Friday till Saturday night. He will have the child with him. The
Almost,
Sunday,
it
yes.
amounts to 2 days.
I'm still losing out on time, but I'm still considering my lord. Sunday I would get.
Commute, not, it's only the commute, it's nothing else. Not
He
commute.
doesn't have to pick up on, drop her on Saturday.
Friday picking her up also, not peak hour traffic. If he has to be there at 3:30, he'll have to leave his house at 2 o'clock. Well, it takes 1.5 hours each way, not less than that to Whitefield. So what I'm proposing is, instead of the child traveling on Friday and Saturday in traffic, not both ways, let the child be with the mother from Friday till Saturday afternoon. Let the mother drop on Saturday afternoon. I'll drop back on Sunday evening. Same amount of hours. We're not changing the hours.
The problem is she would have to take half day from her office and come down. Friday. I mean, we said Friday,
Friday
she has to need.
Not the child.
So Friday you said it's
Friday
comfortable.
mother can have custody.
What my proposal was, my lords, was Sunday could give me because he'll anyways have it from Saturday.
Let's confirm this. This is
My
not
lord,
obliging.
fair.
My lords, may I please
Yeah,
suggest?
say so and so. As the submission as far as that the father is not spending, is not contributing for the child. Land council appearing for the respondent submits that the father is ready to pay 50% of the educational expenses of the child. With regard to the other arrangements, this court is not inclined to interfere. Accordingly dismissed. Disposed of.
My lords, may
Obliged.
But maintenance also is not being.
What
is not
maintenance?
being- He's not even making any contribution towards.
Where is the application?
Application is pending before the family
My
court.
lords,
Domestic
my
violence
lords,
has dismissed the application.
He is
for
having
conduct.
the benefit of visitation, my lords, as well as at the same time he is having.
I think that is not
That's
the
a
part
matter
of this.
Family court has to decide on the
But
basis
still
of
the
AOD.
court has recorded with regard to
My
the.
lords, some sort of modification it is, my lords. Please, my lords.
Not required.
Video call at least could be modified, my lords.
Next.
Serial number 9, adjourned. Serial number 10, H.V. Rajaram.
What is this for permission?
For the petitioner, my lordship.
Please to pass an order of visiting us to see son minor. Yes.
And for the petitioner, my lord. Mogan nododik permission application.
Notice to the respondents.
Respondent.
Notice. Notice to the respondent.
Serial number 11,
Yes.
serial number 11, Lata N.S.
Appears for the petitioner, my lord. I filed this for WP for the enhancement of the
Notice.
maintenance, my lord.
Next.
Yes, my lord.
Serial number 12, Girish B. Beldade.
For petitioner, my lord, petition filed under section 13 class 1 subclass IA of Hindu Marriage Act for a decree of divorce against his wife, my lord.
What is the impugned order?
Impugned order is, my lord, the application filed under order 18 rule 17 read with the 151 of CPC for the opening of the chief examination.
Please come to the order. Where is it?
My lord, page number 53.
50?
53, my lord.
What is wrong with this order dated 22/2?
My lord, the petitioner is ready to pay the.
Nobody. Why for that you should have paid there? Why should you come here and say, I'm ready to pay the cost?
My lord, the petitioner is willing to produce some documents.
What is the impugned order? Is it 22/2/2025? Or which is the date?
My lord, the impugn order is nothing but the petitioners filed application under order 18 rule 17 read with section 151 of CPC for reopening of the further.
Read the reasons from point number 7.
My lord, reasons on careful perusal of the material available on record, it appears to me that the petitioner, being the husband of the respondent, has instituted a petition under section 13(1) IA IB of Hindu Marriage Act for the relief of decree of divorce when the matter stood posted for the further cross-examination of respondent RW1. The counsel for the petitioner has come up with instant application praying this court to reopen the stage of case by recalling the PW1 for the purpose of leading further chief examination on the grounds that in the previous hearing dates, the petitioner could not produce some documents and further chief examination of PW1 is very much essential to prove the case of the petitioner. Along with the instant application, the petitioner has also produced certified copy of FIR with the complaint in crime number 123 of 2024.
Notice the respondent.
Serial number 13.
Petition is permitted to take out hand summons. Yes, next.
Serial number 13.
Yes, Ladyship. Ladyship appearing in this matter on VC.
Adab Singh, opposed.
Yes, yes, Ladyship. Now, Ladyship, in this case, an order was passed by Ladyship herself.
Yes.
Now, that is on Annexure H, page 423.
You're not audible.
Ladyship, am I?
Something is wrong with this. Every time the same thing is happening.
Sir, your audio is not audible. Your volume.
Not about their audio. Problem is with the court's.
No, Ladyship, I just appeared in another coordinate bench and it was very much audible. Am I audible now, Ladyship?
Yes, there is always switched off. Be careful whenever it is. Yes.
Am I audible now, Ladyship?
Yes, yes.
I'm so grateful. Now, Ladyship, we want to indicate your Ladyship's order on Annexure X, which is on page 432. Now, Ladyship, this is the same prayer I'm seeking again, and I have to be very careful in seeking the same prayer again. But what has happened, Ladyship, on the last occasion is an MC matter where, despite your Ladyship's observation that no unnecessary adjournments ought to be taken, on the last 6 occasions, the wife has failed to lead her evidence. 6 occasions, 6 dates.
No, for because High Court is there, you will come and file a petition before the High Court, unnecessary applications like this.
Ladyship, the reason I'm saying that is because there are 2 connected issues in this matter. One is on child custody.
Yours is a 2023 petition.
2022, Ladyship. MC 2022. Yes. Now, Ladyship, what is it? Ladyship, the only reason I have already received an order by Ladyship indulgence that no further adjournment ought to be sought. Ladyship will see page 433. Ladyship's order. In fact, this order.
The court, if court is granting time, there must be a reason for the court.
No, Ladyship, the fact of the matter is 6 consecutive dates. I want to show page 381 onwards. Every single day, the respondent.
What this court says, please come to order at page 432.
Ladyship,
please come to 432.
Yes. Ladyship has said in 432 that para 2.
Para 4.
Para 4. This court has specifically directed trial courts to dispose of the cases till the year 2019 on priority, the cases of the year 22, and this court is not inclined to pass any order fixing a time frame. However, considering the submission of the learned counsel petitioner, this court is passing the following. The trial court shall proceed.
This is a mistake in passing the order.
No, Ladyship, not at all. Ladyship, in fact, there are 2 reasons I'm before you, Ladyship. First is.
I'll tell you one more thing. No, yours is 2022 the MC. No, they will not take up your MC at all. They will only take up 2019 matters. That's the specific direction now.
Ladyship, my only humble submission is.
That's what now I can't, contrary to the directions that are issued by the court. This court cannot pass any order.
Ladyship, I have one submission, Ladyship. Now, there is a connected writ on child custody, which is listed tomorrow. Now, Ladyship, we are aware how Ladyship has granted orders in the past and facilitated the meeting. In this particular case, Say the child is 14 years of age. Since 9, he has been with the mother. Despite directions by various courts, family court, the Honorable High Court, the mother has not let the father meet the child even once. Now, Ladyship, that the Honorable High Court has given a direction that the child, Justice Nagprasanna, that the child should be shifted to the father for a month. Even that order has not been complied with. Then the family court has not taken cognizance, has simply said, you move a section 45 application, we will do an inquiry. Now that writ is listed tomorrow. Ladyship, I will be coming to Bangalore physically tomorrow. I would request both these matters be taken up together because it's very important. And because, Ladyship, we've seen how in
Tomorrow
another
it is
case,
not possible. Tomorrow it is not possible.
Ladyship, there's another connected
On
matter listed
Tuesday-
tomorrow.
On Tuesday,
Ladyship, there's a connected matter already listed tomorrow before Ladyship. This is what I've been given to understand because you
This
moved a
also
mentioning
tomorrow.
memo.
this also tomorrow. Next.
I'm so grateful, Ladyship. I'm so grateful. Thank you.
For the petitioner by my, here the case, my lord, the respondent filed the application under section 151 CPC read with 12 of Guardian and Wards Act.
How much is granted?
My lord, it is not the maintenance, it is a custody of the child.
Where is it?
That, my lord,
Order.
may kindly come to the page number, ring page 23, my lord, order portion. Here the honorable trial court, that is principal family court,
Hereby
Mysore.
partly allowed,
Yes, my lord.
granted right of visitation to visit his minor son and the following Sunday of each calendar month prior to intimation. Also directed permit the applicant foreclose so and so. You are appearing for the father.
Yes, my lord.
What
Here,
is the
my lord,
difficulty with this?
The impugned order, para 12 may kindly be produced, my lord. The 21 page number 21. The para 12, with due regards to the principle laid down in the above cited decision, it could be held that from the co-joint reading of the ratio laid down in all these decisions, it is well settled that while deciding the issue regarding the custody of the child, the court has to necessarily consider its overall development and welfare, has to consider that the child requires equal love and affection. Here, my case before the trial court is that 6/5/2019 marriage is happened. On 31/7/2019, she left.
No, why are you, what is wrong with this order?
That year, from the date of the birth of the child, there was no custody of the child. She went to the Mysore and she did not return back to the Bangalore. And my concern of the is that the interim custody of the child may be given even for a shorter period, even for a single one day of the
No,
month.
how can the court grant like
My
that?
lord, here from the date of the birth,
That's
he
why
is
that
deprived by
all the more reason from the date of birth, he is not with you.
Yes.
Just like that interim custody will not be
Yes,
given.
my lord. In this
First
regard,
of all, acquaint yourself with the child, develop some bonding with him, then only it can be done.
that, my lord, in that regard, the objection is also not serious. The honorable trial court has considered that the visiting rights are given only on the ground that 12/1/2025 is the last date of seeing the child. In this regard, my application paragraph may kindly be perused for a moment, my lord. Page number, ink page number 82, my lord. Para number 7 of my application, paragraph number 7, my lord. Page number
Not
82.
all that. No, according to you, you have never met the child.
Yes, my lord.
Court had permitted you to meet on every second and fourth Saturdays and the following Sunday of each calendar month, so and so. First of all, exercise this.
Yes, my lord. I am saying again, visiting rights have been given. But in this
Overnight
case,
will
my
not
lord,
be granted,
yes,
will not be considered at this stage at all. Because what is your acquaintance with the child?
My lord.
Suddenly, how can the mother send the child to your place?
from 2019 also, I am visiting, keep on visiting until 2025 January month. It is not the case that child was not seen by me from 2019 to 2025. Here my case is that my lord, she is pursuing studies now also, and she is working. My mother is there in the house. She is also having the love and affection towards the child. She can take care of the child in the meantime.
We cannot grant custody, interim custody like that. Visitation, custody will be decided. It's only visitation court has considered.
My lord, my parents.
Want any other arrangement with regard to the visitation? You want any alteration? We'll do it once the respondent comes. Notice to the respondent.
Stay may be granted.
Huh? What
Proceedings may be-
stage?
2024 MC matter.
Why it
Now
should
the
be
trial court
stayed?
is proceeding with the evidence matter. It will conclude
no.
because
That's not the way.
date may be fixed, my lord. So I may be permitted
The
to
petition
serve one.
permitted take out the hand summons on the counsel appearing for the respondent. Once and file a memo to that effect. Once the memo is filed, list the matter.
Cell number 15, Yamparaju.
It's appearing
Yes.
for the petitioner, his husband's petition, my lords. Impugned order is in Annexure C, page 24, my lords. Its Honorable Trial Court has ordered me to pay 1 lakh rupees by next date of hearing, my lords.
Page number?
Page 24, my lords, Annexure C. That's honorable.
Petition both applicants, respondent paid 10,000 to the petitioner. Respondent is to pay arrears of 2 lakh and is a retired ASI directed to appear before the court and to pay at least 1 lakh on next date of hearing. What is wrong with this?
My lords, my difficulty is, my lords, I'm deriving pension of 25,000. I'm retired ASI officer. My lords, my pension documents are produced in page 25.
Go before the court and tell that.
I submitted that, my lords. My lords, I have a loan, my lords. Every month 15,000 I'm
I'm
paying.
saying, when the court said appear before the court and pay, at least that's what it is. On that day, you can go before the court and tell the court, why should you come here?
Lords, honorable trial court has insisted me to pay 1 lakh by next date. If I not paying, my lords, they'll issue an arrest warrant. That's why, my lords. My lords, I'm not shying away
No,
from.
it will be, anyhow, it will be issued because there is an order that is not stayed by any court. So there is nothing for the court to, then nobody
what-
can stop the court from issuing the warrant.
My lords, what has happened?
Where is that order that is passed for granting maintenance? Was it questioned?
Please, my lords, I had questioned. This honorable court has stayed that matter, and,
If that is stayed, why the court will insist for
and
payment?
finally it was confirmed by this honorable court, my lords. At that point of time, some arrears has occurred. From every day,
Court cannot interfere in
my lords,
this.
one small submission. Every date I'm paying 10,000, my lords.
Whatever it is, when an order is passed, it has attained finality. Why will the court interfere in the execution
My lords,
without a proper reason?
my
You
lords,
have to pay.
there is a reason, my lords. Every month 15,000 I'm paying EMI, my lords. Annexure F, my lords, my loan
But
document.
when you are not happy with that order, you should have taken it for a further in appeal.
My lords,
Then
15,000
what is the sanctity for the order?
out of 25,000, my lords. 15,000 I'm paying loan. 10,000 I'm paying to
Whatever
my.
you want to tell the court below.
My lords,
Will not.
every date continuously I'm paying the 10,000, my lords.
Will not
My lords, I undertake to pay 10,000 every month till arrears are exhausted.
No undertaking. Why should this court record your undertaking?
My lords, it may be ordered to pay 10,000 before the trial court itself. My lords, I'm age 67. I'm living on my pension. Every rupees I'm paying to my wife itself, my lords.
So please tell the court, an order is passed. Execution is filed. You do not say any kind of material irregularity in the said order. Why? How do you expect the court to interfere now?
I just need leave of this court to pay 10,000 every month, my lords. I undertake to pay.
Will not. There should be some sanctity to the orders of the court. Whatever you want, you tell the court. Let the court consider. Yes. You want me to dismiss or no? Or I'll issue notice. Notice to respondents.
For admission matter,
interim
serial
order,
number
my lords.
16. N.
Obliged.
Swami N for petitioner. Mohan P. for respondent.
Petitions of this son's petition, Lord, for enhancement of maintenance and also for educational expenditures. Lord, the respondent, Lord, is the father of the petitioner, Lord.
We'll hear this matter on 17th. This 17th.
Serial number
But the
17.
records have not come. But in fact, he's attained majority.
Admit, call for the trial court record.
Call
This is
for-
a matter on 4th of August.
Serial number
17th.
17.
Have it on
Please.
17th itself. 17th itself.
What is
And
that?
have it on 17th itself.
By the time it will come.
Records may not.
It's in Mysore, I think it may come.
Anyhow, 17th, call for the records. Yes.
Serial number 17.
Not,
And
Chandrasekhar
instead
PM.
of 17th,
madam.
not, can it be on not
and
21st or 22nd, not
2nd.
22nd? Grateful.
that balance amount of maintenance was 2,43,000 as admitted amount. And I paid 1 lakh rupees 3 days before marriage. And may request for matter may be referred to the Lok Adalat and all.
Not Lok Adalat, Lordship, if in the court, 1 lakh has been received.
Yes.
Remaining 1 lakh.
This is matter on 10/7/2025.
Yes, yes.
By the time, if an amount of rupees 2,46,240 is not, the stay granted by this court stands vacated. Now it is already vacated because you have not paid.
And I'm requesting your lordship to matter may be referred to the Lok Adalat.
It's not Lok Adalat or mediation.
Lordship, mediation here, before the court itself on the next day, by that time, if they could make the payment.
This is matter before the Lok Adalat. Yes, next.
My lordship, by depositing the said amount, I filed an application for extension of
Already
That-
that stay is vacated. I passed a conditional order to pay the amount by today.
That's
You have
what
not
my-
paid, that is already vacated. Nothing, no further orders needs to be passed.
Hmm.
That I'm not interested in. Yes, next.
Before Lokadar.
Before
Cell number
local.
18,
For petitioner, my lords.
Store Kirti M.
For petitioner.
RPFC 296 of 2024, IA 1 of 25 now. Why? When is the order?
On 4th of October 2024, my lords.
Yes.
My lords, it's a 125 petition challenging the order, my lords. And the maintenance in impugned order, the awarded maintenance is
10,000 is awarded. 10,000 is awarded.
15,000, my lords. 15,000 per month.
So cost of 10,000, 15,000.
She's a BE graduate and already earning 14,000 rupees, and she's admitted, my lords.
What is your income?
Mine is 10 to 12,000 rupees per month. 10 to 12,000 rupees per month, my lords. My gas agency.
Come to the order. When your income is 12,000, why would the court grant 15,000?
They are contended that I am earning 70,000 rupees in gas agency.
You have not appeared before the court.
Sorry, my lords.
You have not appeared before the court.
I appeared, my lords.
You have filed your statements of assets and liabilities.
Please, my lords.
Where is the discussion about that?
In the trial court, I said I don't.
In the order of the trial court, where is the discussion with regard to your statement of assets and liabilities?
In page 18 of impugned order, my lords.
Please read.
In 1, 2, 3, 4, 5, 6, 7, 8 line, my lords. On the other hand, the respondent has produced Exhibit R24, police charge sheet filed against him under Section 3 and 7 of Essential Commodities Act in relating to gas agency, gas cylinders. Apart from the above said document, it is not produced any evidence to show that.
Why you have not produced any document?
Because I was unemployed at that time, my lords.
Bank statement, no bank account for you.
I have not produced.
Half of the amount. Arrears also, it's same, 8 weeks. Next.
Notice. Cell number 19, Mahesh Avi.
Petitioner in this case.
I'm for the respondent in this case.
Last occasion, my lord, we tried to settle the matter, my lord. I offered 4 lakhs rupees. They're saying 7.5 lakhs.
7,50,000.
We already paid 2 lakhs before the trial court. 1,84,000 before this court has been deposited, my lord. Total nearly 8 lakhs been deposited. They are not agreeing for that.
Then we'll hear it on the merits of it. This is the matter on 20th of August. Next 20.
Interim order may be extended.
Interim order granted is extended till then. 20.
Cell number 20, Bindu U.
I appear for the question. Then it's again the interim order of maintenance. 10,000 was granted. Against that, I have come up before your lordship for enhancement. The respondent is not yet served and held to be sufficient. The matter is pending in the trial court. He has not been coming for the cross-examination also.
We'll hear it some other day.
This
This is the matter on 21st.
July. Cell number 21, Kavita D.
Please kindly pass it over, ma'am.
Let's
My
do
lord.
it on 23rd of July.
My lord, we are for a respondent, my lord.
Yes, it's 23rd. Next 22nd.
In this matter, the lords had heard this matter at length on several occasions. My lords would kindly peruse the order sheet. I would point out this order on 10/9/2024, your lordships had passed an order.
We'll hear it some other day, not today.
So Monday or Tuesday, my lords,
This is the matter on 17th July.
please oblige.
Next.
Cell number 23, 24 urgent. Cell number 25.
Your Lordship, appearing behalf of the respondent, Your Lordship. On the last occasion, the child was interviewed in the chamber.
I'll pass orders this matter tomorrow. We'll pass orders tomorrow.
Much obliged, Your Lordship.
And these judgment matters 4 also, keep it tomorrow. Where is he?
ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲ ಮೇಡಮ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್
20? 25.
ಇದು ನೋಡಿ ಈಗ ಅವ್ರಿಗೆ ನಾವು ಅನ್ಕೊಂಡಿದ್ದ ತಕ್ಷಣ
B5 ಇದರಲ್ಲಿ already ಇದೆ. ಇದು 230ಗೆ ಲೋಕ ಅದಾಲತ್ ಇದೆ. ಗೊತ್ತಲ್ಲ ಮೇಡಮ್ಗೆ 230ಗೆ ಲೋಕ ಅದಾಲತ್. 220ಗೆ
ನಾಳೆ ಲೋಕ ಅದಾಲತ್ ಇದೆ.
3672 ಪೋಸ್ಟ್ ಆಗಿದೆ ನೋಡಿ ಇವತ್ತು 3672
3572 ಇದೆ.
35 ಅಲ್ಲಿದೆಯಾ? ಎಷ್ಟನೇದದು? 20ನಾ? ಇರಮ್ಮ ಹೋಗಾದ್ಮೇಲೆ ಹೇಳಿದ್ರೆ ನಾವೀಗ ಇದು ವಿದ್ಯಾ, ಅದು ನೋಡಪ್ಪ ಇದೇನೋ ಲಾಸ್ಟ್ ಅಕೇಶನ್ ಅಲ್ಲಿ